All right. Welcome everyone to one of the afternoon concurrent panels at this conference. My name is Asma Qureshi Landis. I am a law professor at the University of Wisconsin-Madison, which is proud to host this conference. Sadly, it's virtual, but we're really glad to have you here. We have a really wonderful panel that has been put together by this group of people, these group of scholars who have been thinking and talking about this amongst themselves, and now they put this all together for a panel for this conference, and I'm really honored to be able to host it, to moderate it. I'm not going to do a lot of detail, just in the interest of time. We've got 4 speakers and a commentator. I will keep time and I will field questions, but I want to give everyone as much time as possible. So I'm just going to give a really identifying introduction of all of our speakers, and then I'll hand it over to each of them. They have about 15-20 minutes each to speak, and then we hope the rest of the time will be open for questions. I would like to encourage some questions between the panelists themselves. It's obviously going to naturally happen with the discussants, but also if there's any cross conversation that they want to have, and then we'll open up to the group that's here. Thank you all for joining us. All right, so our speakers are Bernard Freeman from NYU School of Law, Jonathan Brown from Georgetown University, Haider Hamoudi from the University of Pittsburgh School of Law, Hava Guni-Rubenacker from Yale Law School, and Mohammed Fadl from University of Toronto. And as you all know, the title of our panel is, what is it, Bernard? Does Islam's Dred Scott problem? Is that right? Yeah. What's the exact title? I don't have it in front of me. All right. And Bernard's going to start us off. Welcome.
All right. Thank you very much. Thanks to the American Society of Comparative Law for hosting this panel, and for all of the hard work that's gone in from my fellow panelists. And it's an honor and a privilege to be a participant in this, and I trust the same will be true for everyone at the end of this talk. The gist of my paper is that with the reemergence and revival of slavery and slave trading by ISIS and its affiliates, coupled with the recent military and political success of the Taliban in Afghanistan, and the actual reemergence of ISIS in that region, the Muslim world is now confronted with what I call a Dred Scott moment on the question of the morality and the legality of slavery and slave trading under Islamic law. Now, the idea of a Dred Scott moment for the Islamic world, the title that we have for this talk, Islamic version of Dred Scott, is a provocative title. I agree with that. And many people have sent emails and asked, what does Dred Scott have to do with slavery in Islam? Just a little bit of a background before I go to my slides. Dred Scott, as everyone knows, has a very negative pedigree in American constitutional history. It's a narrow, positivistic judgment about whether or not Dred Scott gained freedom by going to the free states, Illinois, and then the Upper Louisiana Territory. And then also it struck down the Missouri Compromise because it claimed that the opinion said that Congress did not have the power to legislate on slavery, and that it was up to the states. So it was kind of a positivistic tour de force, and it really just narrowly viewed the law, which at that time regarded Africans as inferior, and that the Constitution did not permit Congress to legislate in the way that it did. It's a very positivistic and narrow decision. Critics have pointed out over the years, there's no secret to this, that the decision ignored the fact that the American body politic at that time was engaged in a fierce debate over the morality of slavery, and the court, by not entering into that debate or not even discussing it, abdicated its responsibility. And as everyone knows, the court really was a precursor, the court's decision was a precursor to the American Civil War. So now what's that got to do with Islamic slavery? And in order to do that, I'm going to go to my slides. There it is.
We tested it out. It's going to work.
There it is. Okay. Now I don't know how to do slideshow there. So, okay. Is that visible to everyone? The first slide really is just a series of questions. I may try to come back to this slide at this time at the end of the talk, but these are questions I think that ought to be asked, and anyone who does Islamic legal history ought to ask with respect to the issue of whether or not there is a moral and legal problem with slavery in the world today, in the Muslim world. And so you can look at those questions, but I'm not going to spend time on them now. I'm just going to go to really the first question, which is that what were the facts with respect to especially the Muslim slave trade beginning really in the 8th century and coming all the way up into the 20th century. And my argument is that it was a holocaustal. It was just like a Holocaust, just like the transatlantic slave trade, if not worse. I just have one example here, the so-called 40 Days Road, which was a caravan track over the desert used to transport slaves into Egypt. It was a constantly life-threatening circumstance for anyone on that trading route. It said that there was about a 30% death rate. And it can be described as the transatlantic slave trade is described as a middle passage in the sense that it was a horror for those who were being transported. Many of them died from thirst, from hunger, from disease, from attacks by wild animals, and from the harsh environment. The numbers, no one's really clear about the numbers of people transported, but I would say that over the 900-year period that this slave trading track was used, you had about 5,000 Africans per year, sometimes more, sometimes less, transported from Darfur in what is today's Sudan up to two towns, Esna and Asyut on the Nile River, and then from there in boats into Cairo, and as the map shows, off into other parts of the Muslim world. It was a horrible situation, and this is just one of 5 major caravan tracks across the transatlantic, across the trans-Saharan area. And this is just one of what I describe as 6 middle passages where Africans and others, Southeast Asians, Indians, people from the Central Asia were transported into slavery in the Middle East. So you have some examples here. This is just 2 photographic examples of the, this is a photograph taken, it appeared in a magazine called The Graphic, of Sudanese women and girls who were emancipated in Cairo after they arrived by abolitionists. That photograph was taken, it said, on the 10th of May, 1890. And then, as I said, there were many middle passages, and one of the other middle passages was the Indian Ocean. And across the Indian Ocean, many hundreds of thousands of Africans were transported into the Middle East. This is a photograph taken. I have some question about the historical, this is taken from the Yale Library, Beinecke Library, and the Yale Library says it was taken by the crew of a boat called the Philomel in 1893. There was an earlier boat called the Philomel, which also did anti-slave trading duties, which operated in the Indian Ocean in the 1870s, and there may be confusion as between those 2 Philomels, but the bottom line is that, as you see from that photograph, most of those captives who were rescued are children, and boys, some girls, and there's a very poignant representation of the sailor in the back with the little boy sitting on his shoulder. So what is this then tell us? Well, I just have the indication there of all of this slave trading, and that went on. It's just the 6 middle passages. I won't take time in light of the time frame we have to describe each one of them, but you could write a book about each one of those middle passages. And so what I argue is that into the 20th century, after the colonial governments took over the Muslim world, illusion of abolition was created. Muslims never really debated the question of slavery, either from a moral or legal point of view. There are no Frederick Douglass's, John Brown's, Harriet Tubman's in Islamic legal history. Abolition was only imperfect, and slavery and slave trading continued even under a regime of abolition disguised as labor migration, domestic servitude, forced and temporary marriage, concubinage, and sex trafficking. In the written paper that I have, there's one case called Khadijatu versus the Republic of Niger, which shows concubinage going on in the Niger in West Africa in the early 2000s and accepted by Muslims in that area. So today we have over 15 million people still currently enslaved in the Muslim world, and the old methods and victims used in the earlier slave trade are still very much in play. So we're faced now with the rise of ISIS and with the success of the Taliban and other Salafi jihadist organizations in the Muslim world with a revival of slavery. And that revival of slavery presents what I suggest is a Dred Scott type moment, the same issue that the Americans were faced with at the time of the Dred Scott decision in 1857. Why that comparison? Well, there's a couple of points here that need to really be emphasized. The moral question that Americans faced at the time of Dred Scott is the same moral question that Muslims face now with the rise of ISIS and the possibility that other jihadist organizations will revive slavery. In the Dred Scott litigation, the court took a very positivistic approach to the question, and I think that many Muslim scholars are also taking a very literalist, positivistic approach to the problem and not looking at the moral question that's involved. And because of that, the criticism that could be applied to Dred Scott will likely, maybe 100 years from now, be applied to those Muslims who say, well, the Quran and Sunnah permits slavery. The Quran and Sunnah are very much still sources of Islamic law, and therefore then we as scholars can say nothing or do nothing or make any argument about the morality of slavery since it is permitted by God. My answer to that depends on much on, and I borrowed to some extent some of the arguments also made by my colleague here, Jonathan Brown, with respect to whether or not that should be so. The Quran and Sunnah clearly, as Jonathan points out in his book, exhort or obsessed with the idea of emancipation, and that obsession seems to have been lost among many people these days. Number two, the Muslim Islamic law emphasizes the egalitarian nature of the law's approach to human beings, and that egalitarianism ought to be a good argument in favor of eliminating slavery. There's also a philosophical argument which I describe as prioritarianism. If you look at, for example, verse 9:60 of the Quran, it puts slaves in a priority position in terms of social justice initiatives. And so that priority position also actually ought to lead to a judgment of abolition, if the welfare of slaves is in fact a priority for Islamic law. And then you have other things which are well known about Islamic law, which are also very much could be placed in play: anti-racism, special protection for women and girls in society, and a fidelity that Muslims are supposed to have toward what is right and good. So if scholars, and I particularly address this talk to Islamic scholars, if they don't step up, if they don't express their objection to what's going on among these jihadists we are in great difficulty. And I think it's what I describe as a Lincoln Douglas Tubman moment. We need Harriet Tubman type people in the Muslim world as well. Harriet Tubman is probably the best example. She took action to rescue slaves. And I think that kind of action and realism is required today in the Muslim world. I have argued, and I do argue in a website, which I will promote here, if you don't mind, if the society doesn't mind. It's called ijmaonslavery.org. And that website argues that there is now a consensus on slavery that should be declared among scholars. And if that consensus is declared and scholars come to an agreement that slavery is immoral and should be abolished, then that abolition could be made effective in the Muslim world. And otherwise, I regret to say that it's likely that we will have military conflagrations in areas where slavery is being practiced, and much suffering and death that will continue. So my argument is for the adoption of that consensus at this time. But I also argue that under the even under the rules of the law as we know it, there is a basis for declaring slavery to be illegal. And it's very difficult to do this kind of talk in 15 minutes, but I think I've made my time. And so I thank you for your attention.
And I thank you, Professor Freeman, for right on time. I didn't even have to use my note card. So thank you so much, Bernard.
Yeah.
All right, next up, we've got Professor Jonathan Brown.
Okay, sorry, 1 second. Just to share my screen now. Can you all see this? Okay. Yeah, I'll just say thanks to everybody for Hava for organizing this, everybody for coming. It's great to see everybody, at least online. So yeah, I would say that this kind of builds on Bernard's talk in the sense he's talking about what we have to do. People should think about going forward in terms of moral arguments going forward. I actually want to look backward and focus on what one might call the kind of moral historical problem of slavery. Another word term for this could be the statue problem, basically, which is that it's pretty well accepted that slavery in whatever form we're talking about is considered, a trans-historical moral evil today. I think pretty much everyone would agree on that. But this is also not just something that's held popularly, but also very clear in things like the 2001 Durban Declaration that talks about slavery was always a crime. But of course, the problem is that essentially the entirety of the human heritage, every major philosophical and religious tradition either defended slavery or considered it natural or condoned it until pretty much at the earliest, the 1700s, and then some not until the 1800s and some not until the 1900s. So the problem is that you have a problem. I don't know, is that my voice? I can't tell. Anyway, the problem is that you have people generally don't want to detach themselves from these traditions, yet you're faced with two problems. The first problem is how do you use, if you're in that tradition, whether it's a legal tradition or a religious tradition, how do you use it to argue that slavery is wrong in the present day? That is something I think that sort of Bernard was talking about, and I'll leave it. It's another subject. What I want to talk about is the other problem, which is how do you explain the fact that and here I'll just talk about scripture. How do you explain that one scripture considered slavery to be acceptable at any point in time? And this is much harder to deal with. So again, you could argue that we have a progressive view of morality or something like that, but if you believe in scripture and revelation, or you believe in some kind of prophetic figure, or at least the kind of moral and legal intelligence of some figure in the past, it's very difficult to explain why that figure ever allowed something that was as wrong 2,000 years ago or 3,000 years ago as it is today. And by the way, that this question was so serious that it really caused major ruptures in even like the way say Protestant Christians in the United States or Catholics in the United States and the UK looked at scripture. This was such a profound question that it affected how people view scripture. There have been two general approaches or ways to deal with it. The first one is to basically go back to the foundational scriptures, let's say the Quran or the Bible, and to reread them in a way that sort of either dismantles or marginalizes or somehow hermeneutically kind of annuls their defense of slavery or their mandating of slavery or their acceptance of slavery. Of course, that will, I'll say always, comes at the cost of delegitimizing the entire tradition built on top of those scriptures. So the entire tradition of commentary and law and stuff then becomes wrong because this whole 2,000 years or 1,400 years, whatever you're talking about, got it wrong because it didn't understand that scripture actually never meant that slavery was acceptable. The second approach, and these two can be used together, but the second approach is kind of less costly, but it actually doesn't really solve the problem, but gives at least some kind of anchor for current moral sentiment, some kind of anchor in the past. And that's to go back and find figures in that tradition who at some point before the modern period, or before, let's say, the era of abolition, had come to the conclusion that slavery per se was morally unacceptable. This is, with the exception of about literally 4 or 5 people in human history, is always wrong, as far as I have seen. And you find it regularly producing, I think, very questionable scholarly conclusions, including one just recently. I remember somebody said, well, the Republic of Ragusa, now Dubrovnik, in I think 1416, that the City Council of Dubrovnik banned slavery and abolished slavery in Dubrovnik. That's not true. It never abolished slavery or ended it. The City Council of Dubrovnik prohibited residents in Dubrovnik from participating in the slave trade. They could still have their own slaves. In fact, they did in Dubrovnik. So this is a kind of example you find where sort of something that seems to maybe be a little bit like saying slavery is morally wrong per se is misinterpreted as being such. And there's a lot of desire for that because people want to have some kind of anchor for this in the past. I'm going to talk about one example. A scholar I have a lot of respect for and a lot of affection for. I consider him to be a very learned and an ethical person and a teacher of mine. And so when I discuss this, I don't do this in any way out of disrespect, or it's just, I think, a really good example of the tension that's here and how people can get caught in that tension. This is Professor Khalid Befuddle, who is a Muslim scholar from University of California Law School, very well known and respected. And in a khutbah he gave, or a Friday prayer sermon he gave in 2019, he said the following. He basically argued that slavery was never actually acceptable or morally accepted in Islam. It was just kind of tolerated as unavoidable. And he says, even the most accommodating medieval scholars in Islam perhaps accommodated slavery as a necessary evil, but they still saw it as an evil. And in 2 of Professor Befuddle's works, one article and one book, he quotes a scholar, Qadi Abdul-Jabbar of Hamadan, who's a famous Shafi jurist and Mu'tazilite theologian who died in 1025. He quotes him as saying that slavery is qubhun fi dhatihi, it's evil or wrong in its per se in itself, and etc. So the problem is that he doesn't give references for this quote, and Dr. Sherman Jackson already examined this, and then I followed up on this as well. And this, I don't think this statement's actually present in the works of Qadi Abdul-Jabbar. We do, however, have the following statement from Khalid Jabbar, where he says something that's actually quite expected from somebody who belongs to his rationalist school of theology. Again, sometimes reason isn't always the best way to go. Rationalist school of theology, which says that basically human reason and divine law have to accord, right? So God can't do anything. Humans can access and understand universal kind of metaphysical morality, and God is beholden to that. So our human reason and our moral reasoning and God's kind of moral reasoning have to be in line. What Abdul-Jabbar says is, since by God Most High allowing slavery, namely making use of slaves, and by his commanding that, we know the goodness, husn, of making such use of them, and the harm this causes them, right? So what he says is that the fact that God allows slavery to happen, and the fact that in some instances, according to Khalid Abdul-Jabbar, he actually commands enslavement to happen, means that it has to be good, because God couldn't command it or allow it if it was evil. So in fact, what Khalid Abdul-Jabbar says is the exact opposite of what Professor Befuddle is suggesting. And again, this is actually very predictable for a scholar like Abdul-Jabbar, who's from a school that sees that what God does has to be good. It can't be evil. All right. I think here it's important to look at what the definition of slavery is in Islamic law. In Islamic law, slavery is called riq. The definition is interesting because it's very hard to, I don't actually know of an early definition of slavery. The first ones you see are kind of maybe from the late 900s, which is pretty long time, several centuries not to have any kind of definition. I think in general, it wasn't defined because it was just a kind of legal reality, that a social and legal reality. But the definition you find that's fairly standard is that slavery is a legal handicap or weakness that inheres in a person because of unbelief. So that the only people who can be legally enslaved in Islamic law are non-Muslims who are outside the abode of Islam. Not non-Muslims living in Muslim lands, but someone out beyond the frontiers of the Muslim state, that they can be enslaved in battle. And that the way you explain, because Muslims believe, like Roman law, that people are born free and the natural condition of human beings is to be free, that the only way that you can lose that freedom is by this process of enslavement. And what they do is they actually have a very non-theoretical kind of ground up definition where they say, okay, the definition of slavery is you take those different legal handicaps or legal weaknesses, that sort of civic weaknesses that slavery causes, and that bunch of weaknesses is the definition of slavery. So for example, in most schools of law in Islam, slaves can't offer testimony in court. In most schools of law in Islam, slaves can't own property, et cetera. So you take like all these different things that slaves can't do, you put them together, and then that actually equals the definition of slavery. Now, one of the reasons I think this was a very poorly theorized, or this is a bad theory, is that it doesn't really explain the accepted details of Islamic law well when it comes to slavery. So, for example, if the cause of slavery is unbelief, then what happens when a slave becomes Muslim? Okay, well, he's still a slave, or she's still a slave. Some Muslim scholars would say, well, that's because that's sort of the after effect of their unbelief that remains with them. But what about a child who's born into slavery? So someone who's not actually ever a non-Muslim outside the abode of Islam, they're born, to a Muslim slave family. Why are they a slave? In that case, Muslim scholars just kind of throw their hands up and say, well, in this case, the property rights of the owner supersedes the right to freedom of the child that's born. And the reason I bring this up, and forget about the bottom part of the slide, but the reason I bring this up is because it demonstrates the importance of the property right in Muslim scholars' legal reasoning on this issue, the property right of the owner. Okay, now I mentioned that Muslim scholars did not, I think it's incorrect. I think it's incorrect, and I think there's no evidence to suggest that pre-modern Muslim scholars believe that slavery was a moral evil. I don't think they could think that, because God had allowed it and the Prophet had done it. And if you said that was evil, you would not be Muslim anymore. And not only would you not be Muslim anymore, but you'd also, even if you were somehow Muslim, you would be kind of moronically following sources of moral reasoning that had demonstrated absolute incompetence at their like foundational level, right? So I think that's an important, I think that's demonstrable, but I understand the urge to think otherwise, but I don't think it's a very convincing argument. However, I think what one can definitely say is that Muslim scholars considered slavery to be harmful. They consider it to be very harmful. And you can see this in an example from Ibn Qudama, a famous Hanbali scholar from Damascus, who says, when he's talking about why is it virtuous to free people? Why does the Quran always tell us to free slaves? Why does the Prophet always tell us to free slaves? Because emancipation is virtuous, because it entails freeing a human being inviolable from the harm of slavery, giving him her ownership over himself and the fruits of his labor, making complete his legal standing, and enabling him to act regarding his own person and his labors according to what he chooses. So basically, it makes him free, it makes the person free, and it makes them a full citizen. And that removes the harm. And this was not just Ibn Qudama who said this. I mean, many other scholars, Ibn Rushd, the grandfather who died in 1126, the grandfather of the famous philosopher and jurist, he says this essentially the same thing. Imam an-Nawawi, famous Shafi scholar, died 1277. And it's interesting because Ibn Qudama actually, in another point in his book, talks about how if you give, it's a very weird situation, but just accept it, which is that you shouldn't give someone a slave as a wife, because a slave woman as a wife, because the child born of that union will be a slave because it follows the mother. And even if the person says like, no, it's fine, I accept the gift, it's wrong to give this slave woman to this person, because it's causing harm to the unborn child, because the child is going to be born a slave, and your act of giving this gift is causing that harm, which is a really interesting manifestation of this harm reasoning. Okay, then the question is, well, if slavery is so harmful, and if they acknowledge it as harmful, why would they allow it? And here there's, I think, two very clear explanations. The first one kind of sociological, and the second one kind of legal, right? The first one is that slavery was a reality in human history. I mean, and this is, one scholar talks about this in, I think, a really impressive way. He says that slavery was essentially like the weather. I mean, you couldn't really imagine not having snow or rain or something. It was just stuff that was like a rainstorm. It's horrible. It happens, and it's sort of unavoidable. So it was just, and in fact, remember, no society that had slaves abolished slavery until the early modern period. I think this is very important. It was simply inconceivable. And the second one is legal, which is that, again, Muslim scholars took property rights very, very seriously. And one of the main aims of the Sharia was to protect people's right to own property and then their right to that property. So you couldn't deprive people of property without just cause. Now, that's kind of a weak argument, I think, and I'll end with this, because as we know in manumission, Muslim scholars were very willing to deprive people of property in order to promote manumission. But I think this just shows on this subject how much maybe inconsistency or tension there is in Muslim legal thought. Thanks very much.
Thank you, Professor Brown. Everyone's right on time. Thank you, everyone. All right, next up is Professor Haider Hamoudi. Haider, you're going to show slides?
Got it.
Yeah, okay,
can you hear me now?
I can hear you. Yep. Now, are you doing slides?
Perfect.
You're doing slides, right?
All right. Yeah, I got slides. I'll share them. Give me 1 second here. Somehow I have everything on the wrong screen, but all right. So thank you very much for giving me the opportunity to speak. Thanks to Asifa for moderating, to Hava for really putting this wonderful panel together, and in particular for welcoming the Shia view, which I suppose is is largely what I'm going to be talking about. And I do think it is I think it offers certain perspectives which can be useful and thought about more, even more broadly. But I appreciate the opportunity in the spirit of greater inclusivity to make sure that the other sect gets represented. And so I'm going to talk a little bit, and I think my talk's going to basically be broken down into two basic sections here. I'm going to first talk about the contemporary traditionalist approaches within Shiaism. And I suppose I should preface that with just a really brief note, which is what really makes Shiaism particularly unique in this day and age is the continued resilience of its juristic academies. The expectation that the juristic academies and those operating within them, the scholars are known as mujtahidun. They're still known as mujtahidun. And so the idea is that these are individuals who practice ijtihad, meaning that they go back to the original sources within Shiaism, primarily the book and the Sunnah of the Prophet and the Imams and the practice of the Imams to derive rulings. This sounds really good to a lot of folks. I mean, it provides this opportunity for a dynamic jurisprudence. It gives you a chance to do what Professor Freeman had said earlier, and even Professor Brown sort of had alluded to, this idea of, well, I'm just going to go back to the original sources. It also creates complications when you have things like slavery, I think, because of what Professor Brown said. I mean, you have material in the original sources themselves that are harder to deal with. And you can't just sort of throw your hands up and say, well, here's what the 14th century guy said, they're from the 14th century. You're supposed to be interpreting from the original sources themselves. And so what you find is within contemporary Shiism, which I have found really interesting, has been that this has been a really interesting moment with respect to the slavery question, because two things have happened to my mind simultaneously. Number one, the traditionalists have gone almost completely silent, and this took a long time. It took a long time to come. But at this point, with the traditionalists, you find very few of the kind of apologetic approaches or defenses of slavery that you might hear in other contexts. They don't try to develop any of the innovative arguments that are being that have already been raised. They just don't talk about it at all. So you have this dramatic sort of silence. But at the same time that you have that, you have this rise of salience among more reformist movements within Shiism who have been bringing up slavery again and again. And I think it has to do, I mean, and I posit within this paper that I'm trying to develop, that it has to do with a challenge among the reformists that the only way to really achieve the kinds of goals to Islamic law that they want to is that you can't simply, I think this draws a little bit on some of the stuff that Jonathan was just talking about, although, obviously in a slightly different context. But you can't just simply on its own apply the traditional rules of the usul al-fiqh, the traditional rules of jurisprudence, and expect a different result. Even if you're newly practicing ijtihad, you have to change the rules of the game. And interestingly, within Shiism, the major source within which there's a desire to change those rules of the game is this one might call it this embrace of reason and unbridled moral reasoning as a means to understand the mind of God outside of and independently of revelation. The Mu'tazila within the Sunni tradition are known to have done this, but the Shia very much hold to this view, at least in theory, to a strong extent. So let me start with the traditionalist approach and sort of give a general sense of what that's all about before I talk a little bit about reformists and how they're trying to argue for a change of the rules of the usul in order to sort of reach a different result. And the reason they use slavery, because of course it's the issue upon which there's the most likely sympathy from a broader audience, because it helps demonstrate how the traditionalism, in a sense, the limits of the traditionalism. So the contemporary traditionalist approaches, what was interesting, as I sort of note here, I have just a couple of representative quotes. It took a really long time for the leading juristic figures within the juristic academies in Najaf and Qom to stop talking about slavery. The general approach was to just keep mentioning these rules, even though they had no actual practical relevance, at least as a legal matter. There was no concubinage in Iraq in 1970, or certainly in 1992. And yet at the same time, there was this sort of strong desire on the part of, well, I don't know about desire. There was this strong inclination on the part of the jurists, desire is far too strong a word, to continue to mention them in their noted Risala Amaliya, the sort of the book that is a compilation of fiqh that every mujtahid has to produce in order to reach a certain level of knowledge. I mean, the highest level being the source of emulation, the one that other people then follow. And I think that there were largely two reasons for this. One was the general prejudice or bias within the within the academies, that those who knew the most about Islamic jurisprudence were those who were able to talk about all of its furu', all of its sort of different divisions and subdivisions, and how deep they could go with respect to specificity of rules within them. If you go to, and the most problematic areas of slavery very often there's a lot of problematic areas that have been highlighted. One of the most problematic, certainly within the context of Shiaism, which talks much less about public law and really focuses much more on private law, is all in the nikah. The book of nikah is often translated the book of marriage, and I think it's probably better translated, at least with the Shia context, is the book of licit sex, in the sense that it's not always contractual. You could have a marriage, and you could also, which was contractual, and then you could have what was called the ownership of the right hand. I mean, it was much more property based than contract based, and the idea that you would just omit this massive part of the book of licit sex, and in particular of the nikah, and in particular to omit something that is not just not discouraged in terms of concubinage, but actively encouraged. In other words, there's this sort of expectation that men need a lot of sex, and so you've got temporary marriages, and you've got permanent marriages, and you've got and then you've got ownership of the
Is anyone else not able to hear him? Oh, wait, okay, hold on.
Yeah, cut off. I don't know
Cut
why.
out there. I was worried it was just me. Haider, you just got cut. Was that just me or everyone else? He cut off. He cut off. Okay.
I
Haider,
believe,
could
yeah,
could
for
you
everybody.
could you just go back to, you were just talking about
Abundant sex.
abundant sex. Yes, thank you, Mohammed.
Okay, I'm sorry. Am I here? I couldn't hear anything. You can hear me now? Okay, I just heard a
Yes.
bunch of sex. That's literally what I heard 4 words. Okay.
Go back to that point because you got cut off. So if you can go
Okay,
back.
I'm sorry about that. I turned off everything and somehow something is on.
All right.
And I don't know what it is, so I'm hoping they don't call back.
So you were saying there are multiple avenues for males to have sex under the presumptions of this.
Yeah,
conversation.
exactly. And one of them is the ownership of the right hand. And so to omit that from the text, at least as a scholarly matter, seems to suggest a lack of scholarly knowledge on the part of the scholar. And I also wanted to point out this whole idea of post-revolution, this sort of post-colonial discourse that existed within Iran that offered defenses, people like Musbah Yazidi in the 1990s of, well, of course we enslaved people. You know, the Christian West and the West, they just killed people, but we brought them into the house of Islam. A very different story than the one that Bernard just told us that, you know, obviously, I mean, we brought them into the house of Islam and we would introduce them to Islam and it was done this way and wasn't this wonderful thing done, et cetera, et cetera. So I'm sorry. Let me go to what tides turn it towards omission. I mean, there's 2 major things that seem to drive this towards omission. I mean, one is obviously as the longer slavery, it becomes more and more of a moral anathema within our times, the more embarrassing it is that you continue to talk about it within juristic manuals. And you can see that's something that Sistani responds to. He doesn't sort of want to not admit that it's sort of there, and so he kind of buries it as best as he can. Literally halfway through the manual that you're reading on the Book of Nikah, he's talking about the rules of withdrawal and whether or not it's permissible as a birth control method. And in comes a footnote, and the footnote says, hey, by the way, it's disfavored with respect to marriage, but it's okay with respect to a slave. Oh, and I'm not going to talk, even though I just told you what the rule was, I'm not going to talk anymore about that rule or any other rules about slavery because it's not something with which we're afflicted, ibtila, in our time, suggesting some level of moral disfavor with respect to slavery only through the selection of the verb, right? I mean, not actually saying it's morally disfavored. I mean, again, it sort of resonates in some of the things that Jonathan was saying before. He doesn't have to, I mean, it's hard for him to say, but he can use the word ibtila to sort of describe it. And then later on, these footnotes go out. I think that the kind of Boko Haram, ISIS kind of stuff that Bernard was talking about within the Sunni tradition have accelerated the move towards silence dramatically within the Shia tradition, because those movements are always regarded as extreme. This gives the jurists this opportunity to say, look at all those extremists who don't know the pure Islam. They're tinged with sectarianism when that's sort of the true Islam, but they don't really know the true Islam. They're not moving towards the true Islam. They're all extremists and they've sort of lost their way. And the slavery thing helps tell that story. But of course, if you keep reciting rules of slavery, that's a little bit inconvenient. And so it really dramatically accelerated this desire among Shia jurists really not to talk about it at all. Right. And so you just get this silence among the top jurists. Now, they just don't talk about it. They just don't want to have anything to do with it, which I've found interesting. At the same time that they've done that, right, and I say, and as I point out, they have the heart, and this again goes back to something that was said before. Part of the problem, thanks, Asifa, part of the problem that they have always faced is the fact that you've got these traditional sources, and these traditional sources say what they say, and it's hard to reconsider using ijtihad. Here's some of the traditional sources within Shiism. I just provide 4 representative quotes here. These are among the more problematic. It is not an overwhelming number of sources that seem to condone slavery, but it is an unmistakable number. It is not merely a begrudging acceptance. It is, you're allowed to do X or you're allowed to do Y with respect to the purchase of slaves, the capture of slaves, et cetera, including, by the way, the purchase of slaves who really shouldn't have been taken as slaves in the first place with respect to these. Now, these are the imams. They are the infallible disciples of, well, I don't want to go into Shia theology, but they're infallibles, and their words are considered sources of law within Islamic jurisprudence. The traditional rules of usul leave you with this problem. And so the traditionalist approach is do the best you can by not talking about it at all. And as I say, what I find reformists do, which I find particularly interesting, is they sort of go back, and they go back to this very strongly held theological principle within Shiism, strong to the point where it gets to highly polemical debates at times, certainly in the pre-modern period, of this idea that God is rational. And God is rational, meaning that human reason operating independently of revelation can determine the qubuh from the husn. And it is a really strongly held view. The traditional view is that while that's true as a theological matter, as understanding God, it is as a form of rulemaking unreliable. It lacks what's called hujjiyah, and to the extent that you have revelatory sources, and as I said, you do have them, you create this level of tension as between, on the one hand, the revelatory sources, and on the other hand, human reason, and the revelatory sources, trump, if you will, because they're just sort of right there. And the result of that is rulemaking has a dramatically diminished effect within Shia jurisprudence. What you find is that among particular reformist typologies, they have always challenged this and said, look, that's that argument seems to be somewhat fraught with tension. Whether it's Mohsen Kadivar, Abdulaziz Sachedina, Shabastari, there's a certain number of folks who say, you've really got to rethink what you're talking about with respect to aql, and whether or not there should be a more bold understanding of what it is that human reason understands and requires. To the extent that something was approved as revelatorily okay in the past, that doesn't necessarily mean that it has to be something that is rationally defensible. It may have been rationally defensible in a particular time in which something was sort of accepted as a given, but those kinds of conclusions can be rethought, reconsidered. And the thing that I sort of really find the most interesting is the fact that reformists seem particularly eager to talk about this subject. And I really do think that there's 2 primary reasons for that when they're sort of talking about the revitalization of the role of reason. Hassan Baluchi, I should say, there's a number of different reformists who sort of adopt this approach, Ali Rida Bojani. The real push, I think, has been to say, look, and the reason that it's such an attractive source is because of 2 things. Number one, you have some revelatory source material, but you don't have an overwhelming amount. That is to say that most of the revelatory source material that deals with slavery, and I gave a couple of quotes here, are about treating slaves like human beings because they are human beings, or even expressing some level of disfavor. one of the most interesting is this idea that the Prophet, through the sixth Imam, Imam Sadiq, says, the most despicable, the most disfavored profession is the one who is involved in buying and selling people. And interestingly, as a vegan, I have to say the second most is the butcher, right? I mean, that's like, these are things that are just distasteful within Shiite jurisprudence. So you have a lot of disfavor, and you don't have a lot of revelatory sources. And then you have this sort of whole idea of moral rationality built around this notion of tawheed, and the idea that the relationship of God to humanity is one that's described as sort of the slave-master relationship repeatedly, right? In fact, worship and slave have the same sort of root. And does that sit well with the idea of one person, a created being, expressing ownership over a never created being, given that sort of nature of that relationship? So I will close there, and thank you for the opportunity.
I was just about to tell you had one more minute. Awesome. Thank you, Professor Hamoudi. Last of our actual speakers, and we'll go to discussant Befuddle, but last of our regular speakers, but not least, is Hava Guni Rubenacker. Hava?
Yes, hi. Thank you.
Some slides too?
Yes, well,
Okay.
First of all, let me try to, presenter view. What I'm gonna do, just first share.
Yep. There we go. Yep, that works.
Okay.
We're seeing it off to the side a little bit though. Put it in the, yeah, that'll do it. Yep, there you go.
Thanks. Well, thank you very much, everybody, for coming and participating, and for American Society of Comparative Law and University of Wisconsin for hosting us. Two scenes from a movie and a TV series that I watched as a child stuck with me ever since. In the movie, there was a Black slave man from the 7th century Arabia who was brutally tortured by his master for defying him and believing in a new prophet of Islam, peace be upon him, who called for emancipation of slaves and equality of all people, which greatly disturbed the master class. That Black slave, Bilal, was bought and emancipated by the prophet's order and was elevated to the honorable position of being the first caller to prayer in Islamic history. For my generation of young Muslims, this was the end of slavery and the beginning of a universal abolition as we know it. In the TV series called Roots, there was a Black slave man from the 19th century United States who was savagely whipped by his master for disobeying him and trying to escape from slavery to freedom. As a child, I was deeply saddened to learn that slavery had continued until very recently in other countries such as the United States, and I was so proud that we Muslims, I had thought, had abolished slavery 14 centuries ago. Thanks to our prophet, who lifted from people the burden, the shackles, and the chains of slavery that were upon them, as it is mentioned in the Quran, وَيَضَعُ عَنْهُمْ إِصْرَهُمْ وَالْأَغْلَالَ الَّتِي كَانَتْ عَلَيْهِمْ. Because he was sent by God as a mercy to all humanity, as it is also said in the Quran, وَمَا أَرْسَلْنَاكَ إِلَّا رَحْمَةً لِلْعَالَمِينَ. It was truly one of the most shocking moments of my life to discover later as a young woman that Muslims too did not actually abolish slavery until very recently in the 19th and even the 20th century. It was extremely disturbing to learn that we Muslims were not even pioneer advocates of abolition in the world, and that we were even pushed for abolition by the Western powers. As if all this was not enough, it turned out we still did not even have an Islamic universal abolition of slavery, but only a time-bound prohibition. The majority of Muslim scholars of Islamic law still believe that slavery is not a universal evil, that slavery and sexual slavery of women could be historically legitimate and moral under certain circumstances, that slavery cannot be universally abolished because slavery is made permissible by God and nobody could prohibit what God made permissible, they argued. But nobody seems to ask the single most important question. Is slavery really permitted under some circumstances by God and his prophet? Are there any clear explicit evidence from the two primary sources of Islamic law, the Quran and the authentic Sunnah, the actual practice of the prophet, for this claim? To answer this crucial question, we will look at the main relevant Quranic verses, the authentic Sunnah that is consistent with the Quran and its prohibitions and commands, and the classical jurist's own principles, rules, and methodology of legal interpretation. A comprehensive doctoral research that I conducted on this very question led me to these crucial findings that, to put them briefly, the Quran and the Prophet never permitted slavery. Classical Islamic law jurists justified slavery based on a legal fiction and deduction that they borrowed from their Greek and Roman peers, which can be called as the theory of death deservedness of war prisoners, and the a fortiori argument, which claimed that because we can kill war prisoners, then a fortiori we can enslave them as well. By these baseless legal fictions, classical Islamic law jurists not only went against the clear instructions of so many Quranic verses and the Prophet's practice, but they also contradicted their own rules and methodology of legal interpretation to justify slavery. Here is how. There are two opposite basic presumptive principles in civil and criminal law about which all Islamic schools agree and which sometimes are confused by non-specialists. In civil matters, they said that, the classical jurists said that, al-asl fil ashya al-ibaha. The basic presumptive principle about things is permissibility, unless there's an explicit unequivocal evidence for prohibition. In criminal matters, however, it's totally the opposite. The basic presumptive principle is prohibition, unless there is a clear, explicit, unequivocal evidence for the permissibility of that criminal act. Because slavery is an originally prohibited crime by the very admission of classical jurists themselves, and because legalizing an originally prohibited matter requires an explicit evidence, also according to all schools, then legalizing slavery requires an explicit, strong evidence from the Quran or the Sunnah. So the right question in this regard is not, is slavery explicitly prohibited in the Quran? But the right question is slavery permitted in the Quran? The burden of proof here is not on whoever claims that slavery is not permitted in the Quran. It's totally the opposite. The burden of proof is on whoever claims that slavery is permitted in the Quran. So now we finally ask the single most crucial question that's long overdue about the legitimacy of slavery in Islam. Is slavery permitted in the Quran? The short answer is absolutely not. There is no single Quranic verse that explicitly permits slavery nor sexual slavery under any circumstances whatsoever. The Quran, in fact, explicitly prohibits enslavement of war prisoners, and it says, فَإِمَّا مَنًّا بَعْدُ وَإِمَّا فِدَاء حَتَّى تَضَعَ الْحَرْبُ أَوْزَارَهَا. When you overcome them fully in a war, then tighten their bonds, but hereafter emancipate them either for free or for a ransom, so that the burden of war may be lifted. The Quran even directly addresses war prisoners themselves in the most compassionate, generous, and dignified way possible, and astonishingly tells them not to be sad about what they have lost materially for ransoming themselves out, and that God would forgive them and compensate them for that property loss if he finds in their hearts a disposition for goodness, as it says, يَا أَيُّهَا النَّبِيُّ قُلْ لِمَنْ فِي أَيْدِيكُمْ مِنَ الْأَسْرَى إِنْ يَعْلَمِ اللَّهُ فِي قُلُوبِكُمْ خَيْرًا يُؤْتِكُمْ خَيْرًا مِمَّا أُخِذَ مِنْكُمْ وَيَغْفِرْ لَكُمْ وَاللَّهُ غَفُورٌ رَحِيمٌ. O Prophet, say to the war prisoners who are in your hands. If God finds any good in your hearts, he will give you something better than all that has been taken from you and will forgive you your sins. For God is much forgiving, most merciful. After such a generous and dignified way of treating war prisoners, how is it imaginable that their enslavement, let alone their killing, would be permitted? After compassionately declaring that God cares even about any property loss that war prisoners might suffer for obtaining their freedom, how is it possible that the same God would tolerate, let alone permit, their subjection into slavery or even their killing? A crucial linguistic fact about a key Quranic term that was discovered by the late Dr. Muhammad Shahrur, a prominent Muslim scholar, laid down before us the uncompromisingly emancipatory and anti-slavery nature of the Quran. It turns out that the word abd is an auto-antonym word, which means that it is a word that entails within itself a meaning and its opposite at the same time. As it is already mentioned in all leading classical dictionaries such as Lisan al-Arab or Maqayis al-Lugha, so the word abd means at the same time both a free and a slave. And interestingly enough, the word abd has two plural forms that clearly manifest its auto-antonym nature and the duality of its opposite meanings, ibad and abid. Ibad means free people, and abid means unfree slave people. Abid is only used 5 times in the entire Quran and is used exclusively and only to describe people of hell who will not have freedom of choice anymore. And ibad is used only for people of paradise and also for all people in this world, because everybody in this world is free and not a slave. Therefore, whenever the word abd is used in its singular form to mean a slave, a clarifying adjective is needed to be, it needs to be added, just like the Quran did. Here's how, in one particular verse. The Quran is a post-slavery text. There is not only no permission in the Quran for slavery, but the word slave does not even exist in the entire Quran, except in one single verse, chapter 16, verse 75, as it says, abdan mamlukan, which means owned slave, where a clarifying adjective is used explicitly and on purpose. This is a descriptive verse and not a prescriptive one. It is not about how things ought to be, but how things are in reality. The verse simply describes the ugly reality of slavery, severely criticizes slavery, and compares it to idolatry, and highly praises freedom and compares it to monotheism. But the classical scholars' big mistake about this verse was to understand it as a prescriptive verse, even though it was simply a descriptive one. Interestingly enough, even when the Quran commands and urges emancipation of slaves, it does not use the word owned slave. It does not use the word abd mamluk at all, but uses a more general term, that is fakku raqaba, which means freeing the neck or the bondage or the burden, which would include slavery, of course, but also all other kinds of social and economic hardship, such as bailing out prisoners or paying the debt of the poor. The term ma malakat aymanukum that appears in the Quran 15 times, and which is commonly and wrongly understood to mean concubines or women sexual slaves, is actually a new term that was not known to Arabs before Islam. The Arabs knew, of course, the individual words malakat and ayman separately, but they did not know this new combination that the Quran came up with, ma malakat aymanukum or milk al-yamin. This was a new modern term that the Quran had invented to simply mean contracts. We have to keep in mind that whatever meaning we deduce from this Quranic term, ma malakat aymanukum, it should be something that is equally permissible to do for women as well, and not only men, based on at least 2 Quranic verses, chapter 23, verses 5 and 6, and chapter 70, verse 30, which obviously include women as well, as the verse says, وَالَّذِينَ لِفُرُوجِهِمْ حَافِظُونَ إِلَّا عَلَى أَزْوَاجِهِمْ أَوْ مَا مَلَكَتْ أَيْمَانُهُمْ Men and women believers are the ones who guard their modesty except from their spouses or their ma malakat aymanuhum. Also, we need to pay attention that the verse says either this or that. It does not say and, because it is not permissible to have both of these types of official and customary marriage at the same time, but only one of them. The plural term aman appears in the Quran 41 times and is never used anywhere in the Quran to mean the right hand. In 3 verses, it is used to mean the right side or the right direction, but not the right hand. It is always used to mean oaths, agreements, and contracts. So ma malakat aymanukum literally means what you own with your contracts. It is a contractual relationship based on mutual consent among free people. When we look at slavery sociologically, as Dr. Muhammad Shahrur astutely explained, we see that slavery had 3 main functions in society all over the world: labor, domestic service, and sex. Even if slavery is abolished and prohibited, these 3 social, economic, and personal functions and needs, which slavery met universally in all human societies, obviously would not disappear. The Quran realistically acknowledges these needs, but orders humanity to meet these needs not through slavery that is inherently based on coercion and violence, but through agreements and contracts based on mutual consent among free people. The universal abolition plan of the Quran, thus, is transformation of slavery into contract, so that labor slavery would be transformed into labor, work, employment contracts. Domestic service slavery would be transformed into domestic service contracts, and sexual slavery would be transformed into a customary or common law marriage or partnership contracts between a single man and a single woman. The main verse that explains the particular conditions of this customary marriage that is different than the official marriage in detail is chapter 4, verse 25. The particular conditions that are required for this type of customary or common law marriage between a single man and a single woman, and its differences from a regular official marriage, are explained in several verses in the Quran, with this verse being the main one, as it says, فَانْكِحُوهُنَّ بِإِذْنِ أَهْلِهِنَّ وَآتُوهُنَّ أُجُورَهُنَّ بِالْمَعْرُوفِ. Marry them, your customary marriage spouses or partners, with the permission of their families, and give them, these women, your spouses or men, their dowers. The verse explicitly commands marriage. There is no single verse in the entire Quran that permits any type of sexual violence against or any sexual contact with women war prisoners without their consent under any circumstances whatsoever. When we look at the actual practice of the Prophet, we see that he perfectly implemented all these Quranic verses. The Prophet never had any slave and never enslaved nor killed any single war prisoner. And the massacre of the Jews of Bani Qurayza is nothing but a myth. The Prophet never had any concubine, and Maria was his legal wife. As it is said in a prominent classical source, Mustadrak al-Hakim, the Prophet married Maria, فَتَزَوَّجَهَا. The Prophet, in fact, openly declared the universal abolition of war slavery once and for all in 630, at the end of the Battle of Hunayn, which was the last major battle he had to engage in, by simply repeating almost verbatim the words of the verse for the chapter 47, verse number 4, which permitted only emancipation of war prisoners, either for free or for a ransom. So after emancipating all the war prisoners of the Battle of Hunayn, the Prophet openly said, لو كان ثابتا على أحد رق لكان اليوم ولكن إنما هو إسار أو فداء. Had slavery been permissible on anybody, it would have been today, but no more. From now on, it is only imprisonment or emancipation. Unfortunately, classical jurists, however, tried to limit the scope of this declaration of emancipation of war slavery by the Prophet to Arabs only, as they extensively discuss in their classical manuals. The Prophet announced convert and fugitive slaves as having a God-given inalienable right to freedom. Dred Scott would have been freed by the Prophet. An Islamic version of Dred Scott cases, in fact, happened at least twice in 628 in the aftermath of Hudaybiyah agreement, and also in 630 during the Battle of Hunayn. And the Prophet considered such fugitive slaves as free and refused to return them to their masters, as he famously said, "Hum utaqa'ullah," meaning that the convert and fugitive slaves have a God-given, inalienable, automatic right to freedom, and that nobody can take it away from them. The Prophet also famously said, Islam amends, erases all what was before it. Al-Islam yajubbu ma qablahu. Al-Islam yahdimu ma qablah. Also, classical jurists said that, and they all agreed, the protection of human life is superior to protection of property. Unfortunately, however, classical jurists contradicted their own principles and methodology and endlessly disagreed about the reasons of this emancipatory act of the Prophet and tried to limit its scope by various excuses. But a few dissident minority scholars, such as Ibn Hazm, severely criticized the mainstream jurists for trying to limit Prophet's emancipatory act for convert and fugitive slaves. Whenever there is an ambiguity in the text, this should have been used not in favor of expanding an originally prohibited serious crime such as slavery, but against it and in favor of expanding emancipation and freedom. Why and on what basis masters' more subordinate right to property is chosen over slaves' more superior and more important and more fundamental right to life and freedom? What clear evidence from the Quran and the Prophet would justify such an utterly unjust and unfair choice? Simply none. In conclusion, the Quran's universal abolition plan consists of 4 steps, or rather 3 steps. First, outright prohibition of war slavery and the addition of any new slaves through war prisoners, and the Prophet's declaration of the abolition of war slavery in 630. 2, declaration by the Prophet of a God-given inalienable right of automatic emancipation to all convert and fugitive slaves. 3, ending the current slave population by urging and commanding emancipation in a variety of different ways. And 4, commanding the transformation of slavery into a contract among free people. In conclusion, there is no slavery in Islam and cannot be, because the Prophet of Islam was sent as a mercy to all humanity and to lift from people the chains and the shackles of slavery that were upon them. Happy and blessed Prophet's birthday to all of you. Thanks.
Thank you very much, Heba. All right, again, right on time. All right, so we have Professor Befuddle from University of Toronto discussing, and by my records, we have a half an hour left. So it's 15 minutes for Professor Befuddle and then 15 minutes for discussion. So go ahead, Professor Befuddle.
Okay, thank you. I don't have a lot of time, so I'm just going to speak very quickly to some big picture items that I think anybody who is interested in exploring this question has to bear in mind. The first thing is, if you're going to approach this question, I think we need to be very clear about the distinction between law and theology. I think all of the papers, to one extent or another, were focused primarily on the theological problems that the historical relationship of slavery entailed. Specifically, is it conceivable that God could have allowed this at some point in time or not? How do we interpret texts that on their apparent sense seem to condone slavery, etc.? But there's very little actual discussion of positive legal doctrine, in my opinion, in any of these 4 papers. So I think it's very important to stress the theological issues, but it's also very important to actually look at granular legal doctrine, of which there is actually a lot, and I think quite relevant to this question. The second thing I wanted to point out is that when Muslim jurists and theologians of the pre-modern era talk about reason, we have to be very clear that their sense of reason is very different than what we think of as reason, right? And so for the most part, when they're talking about issues of rationality of the law, they're thinking about it in a very sort of perspective of moral realism, the idea that these rules have some kind of transhistorical, transcendental, ontological existence independent of us as human beings. So the big debate was whether this ontological reality could be discovered through pure moral, through pure reason. That was sort of the Mu'tazili view and the Shi'i view as it later developed. Or was it a question of divine voluntarism, i.e. God made these rules and we can know them through reading Revelation properly. But in both cases, they adopted a morally realistic view in the sense that they believed that actions had transcendental essences. The only dispute was it through reason or through revelation? Now, I think that we have a very different view necessarily of the ontological status of legal rules. And so we need to be careful about introducing ideas of reason that we might have as moderns and then attributing it to the pre-modern tradition. The other question I think that needs to be addressed in works such as this is, what do we mean exactly by Islamic law? Is it purely divine law? Is it the law only established by revelation? And then what's that rule? What's the relationship of that law to human law, particularly the law, customary law that existed before Islam? And does Islamic law include both kinds of rules? And what's the relationship between the two? And then this is very important. So for example, in my view, for the first 150 years of Islamic history, Muslim jurists did not think that Islamic law viewed as divine law abrogated human law. It's only in the beginning of the middle of the second Islamic century and thereafter that Islamic law begins to be viewed as a branch of theology. And in my opinion, this debate arises in Iraq and it produces things like Shafi'i, Shiaism, etc., where it's crucial to establish some sort of link between every rule and some kind of divine authority. But I don't think that necessarily prevailed for the earliest schools of law, particularly the Malikis and the Hanafis, which happen to be the schools I'm most interested in. But in any case, now, when we study something like slavery, and I think all four of these papers bring this up, what exactly is it that we are studying? Are we studying normative legal doctrine? Are we studying the sociology of law in Muslim contexts? Or are we studying social history? I think it's very important to keep these different points of view distinct and be aware of the different methodologies that each one of them would entail. Now, this panel was posited the question, is slavery evil from an Islamic perspective, at least from a pre-modern Islamic perspective? Well, Muslim jurists don't use the word good and evil. So Haidar used the Arabic terms qubh and husn, which is sometimes assumed to be the same thing, but literally it means qubh means ugly and husn means beautiful, right? Now, I don't quite think those have the same resonances of good and evil in contemporary English. So we need to be careful about that. So I think there are at least two ways we could understand evil. One is in the sense of culpability, moral culpability, and that would be sort of equivalent in Islamic ethical thinking to something that's called haram, prohibited, right? Then there's evil in the sense of tragedy. It's awful. It's something horrific that we need to remedy, right? Now, it might be very hard using traditional Islamic ethical methods of ethical reasoning to come up with a view that says enslavement always results in culpability for the slave owner or the enslaver. Matter of fact, I would say that would require a heroic amount of whiteout to reach that result. But evil in the second sense, tragedy, right? That's very easy to establish, I think, as Jack was showing. I think the Islamic law is full of awareness of how terrible slavery is as a human condition and why it should be remedied, right? Then I think it's also very important, it follows from this, that we need to be very clear to distinguish what we mean, what jurists call ahkam taklif, these moral rules of obligation, rules that demand some kind of action on the part of a human being or prohibit an act on the part of a human being, versus rules of positive law that provide a system of remedies and rights in a context of secular society. And so we need to be careful in distinguishing these two sets of rules from one another in trying to reach a conclusion. So from my perspective, and I can't get into it now, Islamic law has 5 categories of moral judgments. So if we're talking about evil, is evil just that which is prohibited categorically in the sense of haram, meaning if you do it, it's a sin and God will punish you? Or does it also include those categories that are considered disfavored, i.e. makruh, right? That are considered, you not necessarily will be punished for it, but by refraining from it, God rewards you, right? Now, I think it's very easy to make the argument that in fact, from a traditionalist perspective, slavery is considered makruh, disfavored, although very difficult to say haram. Okay. Now, I want to speak a little bit about why it's important to look at the legal dimension of slavery, strictly the formal legal dimension. And that's because from my perspective, you can't understand the law of slavery and enslavement in Islamic law if you separate it from international law, and particularly the international common law of war and property. And you still see this in the 19th century with the very important Hanafi jurist Ibn Abidin, and he just tells you that if a non-believer captures or takes prisoner another non-believer or seizes his property, he owns it or owns him, right? So this is the basic premise of pre-Islamic law, according to Muslim jurists, that force, conquest, is an effective means of establishing ownership. And then this is a very important principle for the earliest jurists, is that Islamic law is not universal. Islamic law only applies in Muslim territory, right? So conquest remains a valid means of the creation and destruction and transfer of property entitlements outside of the territories of the Muslim Commonwealth. Moreover, the law of peace requires Muslims to recognize the effects of pre-Islamic law. So hence you have this paradox, whereas internally in Islamic law on Muslim territory, enslavement is a crime, a very serious crime, right? But when peace is made with non-Muslims, Muslims have to recognize the effects of non-Islamic law, including enslavement. So therefore, jurists say that Islamic law prohibits future enslavement universally, whether the victim is a Muslim, a non-Muslim, whether the non-Muslim is permanently a resident of the Muslim state or just a visitor, right? It doesn't matter. Anybody lawfully present on the territory of the Muslim Commonwealth is immune from enslavement under Islamic law, right? A secondary principle from that is Muslims have an affirmative obligation to liberate from slavery any of their nationals, regardless of religion, that are enslaved, including non-Muslims who are temporarily present in Muslim territory and are powerless to defend themselves against third-party aggressors, right? So it's in this sense that they understood enslavement to be an effect of the laws of paganism, right? Because it's pagan law that authorizes enslavement. But as I said, in their conception, peace forces Muslims to recognize the results of pre-Islamic law. Now, there are lots of resources within Islamic law that should be explored in looking at this question. And I'm going to just point out to a general principle within the Maliki school of jurisprudence, which prevailed in North Africa and Spain and Sub-Saharan Africa. So they had as a legal rule, the lawgiver awaits eagerly freedom, right? Basically, that means that the law should be interpreted in cases of doubt in favor of the slave, particularly in recognizing the slave as free. I think it's also important to look at the positive rules regulating the religious obligations of a slave. So slaves in Islam in principle have all the religious obligations of a free person except for a few, because they are persons as the basic rule is that they are full persons. While a slave, a female slave, does not have sexual autonomy vis-a-vis her master, she is protected by criminal law against third parties. So unlike the law in antebellum South, for example, a slave woman could be the victim of a rape, right? And third parties who raped slave women were punished for that, in fact, right? Physical integrity of slave. In Maliki jurisprudence, a slave who was subject to physical abuse had a right to legal manumission, right? And then there was something in medieval Islamic law known as the Manumission Contract. Now, what was the object of the Manumission Contract? According to Malik, the object of the Manumission Contract is political, not property, right? Because the point of it is to perfect the legal standing of the slave. And so for that reason, it's exempt from many of the strict rules of commercial law, right? And then finally, what are the legal effects of manumission? Because Islamic law viewed slavery as a disability, manumission has the result of removing those disabilities so that the person becomes a full, free person and can enjoy all the rights that any legal person has, right? And this is very important to my conclusion when I get there. Now, many of the problems I think that Bernard rightfully points out need to be understood as unlawful human trafficking, right? And this is why it's very important to focus on formal legal doctrine, because even if you have abolition, as we have in the modern era, you can still have illegal human trafficking. But we can't figure out what illegal human trafficking is, right? Unless we know in the Muslim context what lawful slavery was, right? Now, one of the problems in Muslim society was because slavery was not racialized, except to the extent that Arabs could not be slaves. And everybody, to a certain extent, was vulnerable to human trafficking because there was no racial indicia that made you categorically immune from enslavement if you came from outside Muslim territory, right? So they dealt with this problem of illegal human trafficking. The Malikis had a rule that somebody who unlawfully enslaved a free person was treated as somebody who committed intentional murder and was obligated to pay the compensation due for a free human life. And I mean, 1,000 gold pieces or 100 camels, and had to serve a year in jail and was subject to 1,000 lashes, right? So it's very hard for me to take seriously the claim that Muslim jurists didn't think slavery was evil. I mean, what else do you call that punishment, right? If treating it as the equivalent of intentional murder isn't recognition that it's evil, then it's sort of hard for me to say what is. Now, we also have other kind of evidence. For example, a couple of social historians of sub-Saharan Africa and the transatlantic slave trade point out that we have a paradox in that there's a relatively small supply of slaves from the interior of West Africa to the slave trade. And so they explain this because Muslim polities actually tended to do a good job of following Islamic law and therefore did not export their slaves to European slave traders, even though there was a huge price difference. So if they were profit maximizers, right, then they would have gladly broken their laws and sold them to European slave traders. And they could have done, they were like the least cost providers, according to this article, but yet they didn't do it, right? And then one other point that's very interesting, I call it the dog that did not bite, the dog that did not bark, excuse me. In Islamic law, in theory, an owner could arrange marriage between a male slave and a female slave, and the child would be enslaved. So it could have been a profitable business to produce slaves domestically. Yet apparently that never seemed to be a vehicle for commerce in the Muslim world, right? It just didn't seem that Muslims ever engaged in the production of slaves domestically in any kind of systematic fashion. Now, turning to this Dred Scott problem, I think it's very important. I'll just say honestly, when I saw the title, I will admit I was a bit offended. Not because there aren't horrific problems of human trafficking and horrific problems of sexual abuse and horrific problems of all sorts in the Muslim world, but because it's just inaccurate, right? The whole point of Dred Scott was to show that under no circumstances could a descendant of an African slave be a legal citizen of the United States, right? But as I think as any kind of fair reading of Islamic law shows, manumission had precisely that effect. The whole point of manumission was to give people the full rights of a citizen. And in fact, that happened regularly, right? So that's why I think the comparison is just way, way off and misleading. So I do think that it's really important for Muslim societies to focus on problems like human trafficking. I'm just not convinced by putting it in the frame of the theological problem of slavery, it helps us get there. So thank you.
Thank you so much. All right, right on time again. Thank you so much, everyone. All right, what I'd like to do is give the panelists a chance to respond either to each other or to Professor Befuddle, who was our discussant. Maybe we can do 5 minutes of that, and then I'll open it up to the general group. Thank you all for joining us. Because there's so many here, I'd like to see hands, and Bernard Vetter has already anticipated my request, so thank you, Bernard Vetter. So is anyone from the panel would like to say anything to each other or to Professor Befuddle?
Also, there's one thing I forgot that's actually very important.
Go ahead. Mohammed has something to respond to himself.
Yeah, sorry, I omitted this. It's actually a very important point. Although, you know, there is already consensus that slavery is illegal because there's a consensus from the first days of Islamic law that it's illegal to enslave anyone that you're at peace with, right? And because of universal peace through the United Nations, it's impossible for anybody to be legally enslaved under Islamic law. There already is a moral consensus about that, right?
But that doesn't solve the ISIS problem.
Well, they're criminals, right? There's human traffickers. Those are just criminals. ISIS are just criminals. I don't understand why that should be a problem. They're criminals.
Hi there, Hamoudi, Professor Hamoudi.
Yeah, I mean, I might have it. I mean, with respect, I'm thinking, and again, I talk from a different school's context, and so it is possible that, but it does seem to me that the description of the legal doctrine is somewhat optimistic in that account. I mean, if you do, in terms of sexual autonomy, certainly within the Shia tradition, the legal doctrine, if we're going to turn to the legal doctrine, we can do that. The owner can marry or divorce his male and female slaves, and if he divorces his male slave, the female slave is his for his enjoyment. He can also gift his female slave the tafwid the delegation of the vagina. You can't be any more explicit and obvious than that. And the idea that a turning of a blind eye and the permissibility of purchasing and selling human beings who may have been illegally obtained in lawful markets, I do think at some level there's at least ambiguity in the legal doctrine with respect to whether or not we turn a blind eye towards this kind of human trafficking, or at least tolerate it at some level if we look at the legal doctrine. I am interested in talking more about reason, but I'll get into that later. I'm interested in Mohammed's views on that.
Mm-hmm.
I agree with Hyder's last point, especially on the ownership. Mohammed mentioned the ownership of a woman by a man, and that someone else could not sexually assault her, but at the same token, he could, even though there's no marriage, he could, whenever he wanted, sexually enjoy that woman. And that, my argument is that kind of relationship, I cite a case in the written paper I submitted, the draft, called Khadijatu versus Niger. And this man actually prosecuted her for bigamy when she tried to marry another because she had been his concubine. And that case was decided 2008. So it seems to me these kind of concubinage relationships and other forms of relationship like that still exist in the Muslim world. And if there's a consensus, people don't know it. The good thing about a consensus is that people have to know that it exists.
Right.
They don't know it.
Right. Jack, go ahead.
Yeah, I just want to say really quickly, I mean, there's two types of consensus. There's consensus that scholars know about, and there's consensus everybody knows about. So this could be a consensus that only scholars know about.
How about, go ahead.
So yeah, if we, when we look at I very briefly mentioned the doctrine, the core doctrine that by which classical jurists try to justify slavery, and that is the deservedness of war prisoners. So they just assumed without any textual evidence, and to the contrary, presence of a textual evidence against killing war prisoners in the Quran, which I mentioned. They just assume that because we can kill war prisoners. Therefore, a fortiori, for a stronger reason, we're gonna assume that we can enslave war prisoners. And they totally contradicted themselves, because they already prohibited mutilation, rape, torture of, at least, I mean, when I say rape, of course, in the terms of sexual slave of women, it was allowed, but for male war prisoners. So they already admitted that torture, anything less than killing, such as these criminal acts, were not permitted to do against war prisoners. So if you say we can do to them anything that is less than killing, then you should be allowing all the other criminal acts as well. And if you're not allowing all the other acts as well, then on what basis you're allowing, you're picking and choosing, and you're allowing enslavement? And they themselves admitted that freedom is the basic principle for everybody in the whole world. And then they already said that legalizing a criminal act, which slavery originally they considered to be a criminal act, it's a violent act against somebody. So in order to justify that, you need to have strong evidence. And they just did not looked at it from that perspective, that they needed to bring textual evidence to justify and permit what they were doing, and not the other way around.
I think we should open it for questions.
Jack's got his hand up, and then just one last word from Jack, and then we'll go to the questions. Yeah, I agree with you, Bernard. Jack, one thought?
I just want to say, I mean, I think, Hava, my issue with your reasoning is that it's sort of circular reasoning, right? So you said at the beginning, you're going to look at the hadiths that agree with the Quran's message, which you've identified as having a certain meaning. I mean, the fact of the matter is, jurists didn't theorize slavery from a theoretical perspective. They built the theory, they induced it basically from the fact that you had dozens and dozens and dozens and dozens and dozens of hadiths that they considered to be sound, that clearly had people enslaving people with no objection, and it was considered justified. So then the question is, how do they, if it's allowed and it's accepted as part of Islam, then how do you theorize it? That's when they brought in this kind of Roman death deservedness issue. So I think that's, I think starting from that point, and to criticize the idea of slavery is sort of going back. I mean, I don't want to say it's going backwards. It's like, it's just starting from a point of departure that it was actually flimsily argued by Muslim scholars, but it wasn't their core evidence.
Yeah. All right, thank you, panelists. Bernard Vetter, go ahead and ask your question and unmute yourself. Go ahead. Where did he go? Well, there he is. He's still not there. I'm going to ask him. Maybe it was an accidental raised of hand.
He's at the bottom, but I don't.
Yeah, I see, but he's not unmuting. Maybe it was an accidental hand raise.
Okay.
Must be questions. I assume there must be some
There's got to
questions.
be questions. Yes, everyone. Well, there we go. I got Ozgen. Ozgen? Is it Ozgen or Ozgen?
Ozgen.
Ozgen, go ahead.
Unmute yourself, please.
Yeah, we've got.
Yeah, okay, all right.
There we go.
Sorry.
Yep.
Hi,
Yeah.
everybody.
Can you hear me?
Hold on, I've got two people talking. I think, was that Bernard Vetter talking?
Yes.
There it is. Okay, we'll go to him and then Ozgen. Okay, go ahead, Bernard.
All right. First of all, Bernard, I want to thank you for clearing something up for me. And by the way, I have to say that this is one of the most stimulating and panels that I've heard today. The different views that people have, but each of them presenting a really good argument for their views. But Bernard, as I said, I want to thank you for clearing something up for me. I had an interesting experience. I taught last year in Saudi Arabia, and I'm sure that I can't remember the authority, but I'm sure that there were more sub-Saharan slaves taken by the Arab world than by the West. And I looked around in Saudi Arabia and I saw no evidence of them. I mean, I'm from Louisiana. You see that there's an evidence of them in other places. But by showing that they were taken to other areas, you've answered that question. Just out of curiosity, were the most of the slave traders from Saudi Arabia, or am I assuming too much?
No one's really done any kind of study on who the slave traders were. In fact, we don't really know very much about slaves, although that we know that Africans were a large number, but there were people from Southeast Asia, people from Central Asia, people from the Indian subcontinent among the slaves. I don't think any real demographic or ethnographic study has been done. And it's very hard to get the evidence of who the slave traders were. There's a very famous slave trader, for example, in East Africa named Tipu Tib, but Tipu Tib turned out to be half African and half Arab. He's what you call a Swahili. And so you have the whole Swahili national ethnicity there, where people are really of mixed race. And so you had a number of African slave traders too. I'm not trying to say that all the slave traders were from somewhere else. The Africans actually engaged in quite a bit of slave trading themselves.
Thank
Yeah.
you, Bernard. In the interest of time, Bernard Vetter, do you mind if I just ask if there's any other questions in the room
Sure.
before you follow up, just because we are just 3 more minutes here?
Yeah.
Thank you. Forgive the intrusion. Again, did you still have a question?
Well, actually, a question to ask, but I'm going to ask, like, I mean, to have
Go
one.
ahead.
And so I understand that it is not openly actually prohibited in the Quran to enslave other people. So it is implied, right? I mean, but then like when you look at, for example, drinking is haram, like strictly it is forbidden. Like adultery is strictly forbidden. Like, you know, I don't know, like killing somebody is strictly forbidden. But when it comes to like, you know, slavery, why I'm just having a hard time to understand. I mean, maybe like, you know, how I can help me, like, you know, why it looks kind of like implied that, you know, I mean, it's just in a few like verses, maybe like 1, 2 like hadith accounts. So, but then actually it should be equal to, let's say, like killing somebody, right? I mean, like it's you know, like it's or torturing somebody. I don't know. Maybe here. I mean, how I could, if she could, you know, make some, you know, comments.
Sure, thank you very much. This was for the time for time limits. I couldn't, you know, elaborate, but there's answer to that. There are actually 2-3 verses in the Quran that that in the same way for emancipation, Quran did not even did not name the word slave. Abd did not use it. Similarly, for prohibiting slavery, did not use the word slavery, but also we have other examples like torture, rape, mutilation, pedophilia. So all these acts we do not have one by one mentioned, but as a one single category in chapter 7, verse 33. قل إنما حرم ربي الفواحش ما ظهر منها وما بطن والإثم والبغي بغير الحق. So under البغي بغير الحق, taken from somebody anything against his or her consent. So it's bodily integrity, sexual integrity, anything you're taken by force, sex from that person or property or part of his body. So all this is included under tahrim. So uses the word haram, universal prohibition. So all these acts, including slavery, you know, can be prohibited under this this verse. And also under when it says وَلَا تَقْتُلُوا النَّفْسَ الَّتِي حَرَّمَ اللَّهُ إِلَّا بِالْحَقِّ, don't kill living being or soul. It doesn't say human, and it doesn't say body, because all psychological killing, like slavery, the classical Jews admitted that it was social, it was death. They said الرق كالهلاك. So they agreed with Orlando Patterson in his description of slavery being social death. So all these verses that prohibit killing a soul, a human soul, both physically, it can be understood to kill both physically and psychologically or socially, like in the like in the example of slavery. So all these verses could have been interpreted. And just a very last point on all this hadith being, the Prophet never practiced slavery and never permitted. There is not one single hadith from the Prophet that says,
Well,
you guys,
di-
you people
didn't-
can enslave
Didn't
one
he
person.
accept, can I answer, Hawa, didn't he accept a woman named Maria from the Caucasus of Alexandria and her sister Sirin as gifts? And then he gave Sirin to another member of his group, I don't remember the man's name, and he kept Maria for himself.
As a legal
Now-
wife, as a legal wife.
Well, what evidence is there that he married her?
In
What
Mustadrak
evidence do you have
al-Hakim,
of that?
right, as I mentioned in my presentation, in Mustadrak al-Hakim explicitly says that فَتَزَوَّجَهَا, he married Maria.
So as you can see, we're at time and there's plenty more to say. And I'm really sorry, Yasser, that you've got your hand up, but I'm just trying to honor my job, which is moderator. If they don't cut us out of here and some panelists are willing to stick around, I'll have your question, but I do need to close the session. I want to thank everyone. I was very honored to moderate this, as Hava described it to me when she emailed me. I think this is a historic conversation of scholars at this level having this conversation with the same emotional concern over the issue, but also trying to be as honest as they can to their own scholarship and the material that they're looking at and they work with every day. And I also want to add that as a program being put on at the American Society of Comparative Law, I really, really respect all of you who have jumped into the deep end in Islamic legal analysis here. If you are not familiar with Sharia and fiqh, this was a heavy lift and we appreciate you sticking around. And I'm just really glad that we've gotten to a point in comparative law that can happen. We'll just have a presentation with no definition of Sharia to start us off and we just jump right in. So I appreciate everyone for sticking around. If they don't cut us out of here, I'm not in control of the admin. So Yasser, if you'd like to stick around and whatever panelists are willing to answer your question, I'll stick around and facilitate that. But thank you everyone for joining us and have a wonderful weekend.